DCPS charter. Please note that Section 3 says the district school board shall provide for reimbursement for reasonable expenses for legal services for officers and employees, and the officers are the school board members. In my public comments, I mentioned 6.83, which is a requirement for employees, but not a requirement for the board. And I mentioned that I think this should be included in that board policy 2.29 to make this a requirement of the board as well. On this agenda item 51, there might be some good things in it, but it needs a lot more discussion. If you approve item 51 as it is written, it may embolden board members to break the law. It appears to me agenda item 51 also violates Duval's charter. Agenda item 51 needs more work. Another example is you need to include a clause that board members are subject to the professional standards required of employees enumerated in board policy 6.83 and 6.84. Agenda item 51 might embolden board members to break the law if taxpayers are required to reimburse them for questionable attorney fees. Like if the attorney is kind of shady and you can go get this attorney to defend you, and the attorney is able to, not get a guilty plea, and then the taxpayers still have to pay the attorney because that's what this rule is saying. And if you stick with the Office of General Counsel and use them as your attorney, we know they're reputable and they know they're good. And even they have Mr. Poole here today, who we all love, of course, but the Office of General Counsel hired him. Y'all didn't hire him personally. So what if a board member did what Clayton did and wanted to hire an unethical attorney? Taxpayers could potentially be required to pay those attorney fees. Now, I don't mean this as an attack, because I know I'm not allowed to say attack, but I have heard April Carney, school board member April Carney, yell at staff. Well, that could be considered bullying. Does she think she can continue to bully staff? And then one employee might want to bring a civil suit. But maybe she wants to hire her own attorney and define what she did is not really bullying. So I just don't think a board member should be able to hire their own attorney. And also, Charlotte Joyce, and I feel sad for her. I've lost my dad as well. It's very sad, but it doesn't mean I can't speak that she has blatantly ignored court precedent over the Establishment Clause of the First Amendment. So I'm worried about these board members not obeying the laws, not obeying our Constitution, and hiring unethical attorneys. So I hope you will. Please read Section 3. The district school board shall provide for reimbursement for reasonable expenses for legal services for officers, aka board members, and employees.
Okay. Yes, thank you through the chair to the board as a whole, and also as by way of explanation. There's a Florida statute that provides that if an employee or a public official gets sued civilly or prosecuted criminally by reason of the fact, the performance of their jobs or their official functions, then the governmental entity for which they are employed or with which they're employed or for which they perform services will either may advance representation, and what that means is provide it up front, or indemnify the employee or official for legal representation, that is to reimburse them on the back end for the legal fees associated with that, either criminal prosecution or civil lawsuit. And by the way, if you're a corporate officer, there's typically the same type of provisions. So it's not unique to government employees and officials. The way the policy is written currently is problematic for a couple of reasons. First of all, when it comes to criminal matters, the Office of General Counsel does not provide criminal defense representation for city employees or local government officials. That's not what OGC does. It's a provides civil representation. So then the question is, with respect to criminal representation, well, gee, if OGC does it, and by the way, I'm no longer with OGC, for those of you who may not realize that, but, so if I speak about it as a third party, understand that. So then the question is, well, what the heck is going to happen with those people? So what OGC then has to do is authorize outside counsel to provide criminal defense to an employee. The second issue that comes up is, well, are we going to, in advance, provide representation for somebody in what is termed advancement versus indemnification? Or are we going to let that person retain their own counsel and then reimburse them on the back end? A problem with that can be if you advance representation to somebody on the front end. Let's say, for example, you're charged criminally, and using the example you mentioned. You're charged criminally because of some misconduct with a student. And then they say, well, you know, we need criminal counsel. Well, if they're convicted, if they plead nolo contendere, they're convicted, well, if we fronted the money to them, good luck getting it back, getting reimbursement for that. And so that's why the statute will say, you know, local government can do one or the other. As a practical matter, in my experience, it's been, they're going to do it, they're going to provide reimbursement in criminal cases, avoiding that expense up front. And you know, and if they've done nothing wrong and they get acquitted, then they present you with the bill and you pay them back for that. So that was the idea behind this.
So through the chair to Dr. Bernier, do the change from shall to may and the change from paying up front to reimbursement, is that a financial advantage for the district?
Yes.
Member Blunt.
Through the chair, to Mr. Poole, just to clarify, an employee gets in a situation to where it's a criminal action, a bad one. What you're saying is the Office of General Counsel will not cover gross criminal action, and that they don't necessarily have to refer them to the outside. The person is pretty much on their own, right? Like, say, a murder or, you know, something really bad.
So that's correct. So to Board Member Blunt, so if someone were to, trying to think of an example, get into a fight at work and they cripple a coworker, and now they're charged with aggravated battery. It's clearly a criminal, and it's happening at work on the clock, and there's a dispute between coworkers. The way this is written at this point, I would still argue that that's outside the course and scope of employment. We'd have to argue that out. But let's assume that it arises out of the performance of their job, and we don't really have an argument. And it may be misconduct nonetheless. But the way things stand right now, OGC does not provide criminal defense attorneys, does not have the capacity to do that. So what would have to happen, as currently written, is you have to run it through the Office of General Counsel to get permission to, if they're exonerated, then they got reimbursed.
And I want to ask
civil
further
case.
question. And in the case of this, because I'm thinking about the district as a whole, this happens with a person, the general counsel doesn't defend them criminally in those cases. But I wonder, because I don't know the language in here, if the school board would still be responsible just because that person was an employee. Or could they I guess this is getting deep legally, but could the school board, the school district, be responsible or be sued based on what that person may have done? The general counsel says, we don't handle that, you'll have to get your own attorney. And whomever the victim was, would they, in any case, be able to come after the school district also, and the general counsel not supporting that person in any kind of, criminal case?
So, Board Member Blunt, let me make sure I'm clear on this. So if OGC says, hey, we're not going to represent you,
Right.
would the employee then have recourse against the board? Is that the question, to enforce the policy as currently written?
It only had number 1 and number 2 in it. And it said for board members, the Office of General Counsel shall provide representation. And in number 2, it said for employees, the Office of General Counsel shall provide legal services for the employee. Meaning, in civil cases, the Office of General Counsel can handle that, right? And they would provide representation. In criminal cases, that has to go, if it says shall, then the Office of General Counsel is required to go find a lawyer for the employee and pay for that employee's defense up and through the time of adjudication. If they're found guilty, we have to ask them to pay the money back. This policy, because it now says may, gives the general counsel the option in that criminal case to say, we're not providing you representation, go find it yourself, get a not guilty verdict, then we can talk about reimbursement. That's the change.
Thank you
So
so
if we
much.
think they're guilty of sin, do we really want to pay for their defense up front?
The school board voted on this policy July 1st. Please note that section 1 changes shall to may. Does that violate Jacksonville's charter? Please note that section 3 says the district school board shall provide for reimbursement for reasonable expenses for legal services for officers and employees. And the officers are the school board members. And notice that the section 3 allows the school board members and employees to hire an attorney of their choice. And it makes the school board have to reimburse them. Notice they use the word shall. You'll notice in section 5, for a judgment, they do say may, so it could be may not, may or may not. But section 3 definitely says shall.